Well, thank you, Rick. I am deeply honored to be here on this great symposium. I've learned so much. I'm not sure I have anything more to add to what went on this morning and this afternoon. But I want to start by pointing out that there was once an Arab Spring. You remember that phrase. But before there was an Arab Spring, there was an Atlantic Spring, a series of democratic revolutions that took place from 1776, the last quarter of the 18th century, into, I think, the next 50 years, if you include the revolutions of 1848. All of those revolutions followed the American Revolution. We were the first. Now, our revolution was no mere colonial rebellion. It wasn't like the Algerians breaking away from France in the 1960s. In American eyes, and I think in the eyes of many Europeans, our revolution was a world historical event. Richard Price, who was a dissenting minister in London, said that in 1785 that the American Revolution was the second most important event in the history of the world. The first, of course, to him was the birth of Christ. Now, the French Revolution erupted 13 years later. Now, because it was such a momentous upheaval, the French Revolution has tended to dominate Western consciousness. But it followed the American Revolution, something the French have never forgiven us for. Many French leaders, however, believed that they were following American leadership. Lafayette sent the key to the Bastille, the symbol of the Ancien Regime, sent that key to Washington, and it hangs today in Mount Vernon. So ours was not a mere colonial rebellion, but the overthrowing of monarchy. That is, I think, better understood as authoritarian government, because many monarchies, half of NATO is made up of monarchies. So we have to understand the world they lived in. Monarchy is what we mean by authoritarian governments. And the establishment of republics, which I think are better understood for us as democracies. Saddam Hussein's Iraq was a republic. Mubarak's Egypt was a republic. So republic has a different meaning for us. So if we use those terms, republic, and interpret it as democracy, I think we better understand what they were talking about. So the Americans aimed not to simply to destroy British tyranny, but to put an end to tyranny once and for all. Their revolution would become an object lesson to oppressed peoples everywhere. They had a responsibility, they thought, to show the world how to create and sustain democracy. They would lead the world toward a new libertarian future. Yet all these other Western revolutions that took place on both sides of the Atlantic over a 75-year period, up through the revolutions of 1848, all of them failed. Every one of them except one, ours. Now, I'm asked many times, why did our revolution succeed and all these other revolutions over the next 75 years, revolutions to establish republics or democracies, fail? I think the short answer, the best answer in a word, is that the colonists, or at least most of them, and certainly the leaders, were Englishmen or Britons. And even when they were not Englishmen, they thought they were Englishmen. John Jay, who was one of the most important of the founders, was 3/8 French and 5/8 Dutch, without any English ancestry whatsoever. Nevertheless, Jay could declare with a straight face in Federalist No. 2, the Federalist Papers, No. 2, that Providence has been placed to give this one connected country to one united people, a people descended from the same ancestors, speaking the same language, professing the same religion, attached to the same principles of government, very similar in their manners and customs, and who by their joint counsels, arms, and efforts have nobly established general liberty and independence. That Englishness was important. It made all the difference in the success of our revolution compared to the other unsuccessful revolutions that took place over the following decades. The French, for example, had few of the rights and protections for liberty that the English took for granted in the 18th century. Their Estates General, which had never had powers comparable to the English Parliament, had not met since 1614. Thus, the National Assembly that met in 1789 to bring about the French Revolution had very little experience with self-government to fall back on. By contrast, our founders had a long English heritage of law and rights to draw upon, and no people in the world were more obsessed with their rights than Englishmen. The English colonists also had a long experience with elective self-government. They had been electing representatives to their colonial legislatures for generations, and in some cases for over a century. They had the broadest suffrage of any people in the world. 2 out of 3 adult white men could vote. Now, this is not democracy by modern standards, of course. Women could not vote. There were slaves in almost every state. But certainly, the colonists experienced the greatest degree of democracy in the world at that time. In England, which was, of course, the most democratic government of the major European states in the 18th century, only 1 out of 6 adult males could vote, compared to our 2 out of 3. Now, of this English heritage, nothing was more important, more symbolic of the colonists' rights than Magna Carta. That 13th century feudal document came to stand for almost everything that Englishmen cherished, for habeas corpus, for trial by jury, the common law, even for no taxation without representation. So it's not surprising that in the great debate with Britain in the 1760s and 70s over the nature of the empire, that the Americans would refer over and over to their rights as Englishmen and regularly cite Magna Carta as evidence of those rights. Until almost the moment of independence, they correctly insisted that they were revolting not against the English Constitution, but on behalf of it. Now, during the quarter century or so of constitutional debates that took place, first between the English and the colonists between 1764 and 1776, and then the debates that took place among Americans themselves between 1776 and 1787, or 1791 with the formation of the Bill of Rights. Magna Carta in this whole 25-year period was constantly cited. More than any other document, it came to stand for what Americans meant by rights and by liberty and their liberties. One of the most important images of the Revolutionary era is Paul Revere's depiction in 1775 on several Massachusetts paper money notes of a Minuteman carrying a sword in one hand and a copy of Magna Carta in the other. It became the seal of the state from 1775 to 1780. The colonists justified the meeting of the First Continental Congress in 1774 by comparing it to the Assembly of the Barons at Runnymede when Magna Carta was signed, they said. As you all know, some of the important clauses of Magna Carta were eventually incorporated into the first 10 amendments to our Constitution, into the Bill of Rights. Now, the story of Magna Carta in the American Revolution sounds simple, but I don't believe it is. There was a good deal of confusion over what precisely Magna Carta meant on this side of the Atlantic compared to what it meant in England. Indeed, Magna Carta became an important element in the divergence, the divergence that took place during the Revolution between American and English constitutionalism. Magna Carta contributed to the Americans' realization that the fundamental laws had to be written down and separated from the institutions of government, something the English have never done. But then in 1787, 1788, during the debate over the ratification of the Constitution, Magna Carta seemed to decline in importance. The supporters of the new federal Constitution came to the conclusion that Magna Carta no longer had any relevance for Americans, any applicability. When the adoption of the Bill of Rights in 1791 took place, however, Magna Carta was once more placed at the center of American constitutionalism. So you can see the story of Magna Carta in the Revolutionary era has been an up and down one, and I think very complicated. And I want to try to explain what happened. Now, in order to understand the role of Magna Carta in Anglo-American constitutionalism, I have to give you a brief survey of English history, at least as good Whigs in the 18th century understood it. English Whigs on both sides of the Atlantic saw that history as a contest between two principal elements, the king on one hand, the people on the other. Each of these two contestants had rights. In that distant medieval world, the world in which Magna Carta was created, the king's rights, usually referred to as the king's prerogatives, gave him sole responsibility to govern the realm. And these rights of the crown were as old and sacred as the rights and liberties of the people. That responsibility of the king to govern meant providing for the safety of his people and seeing that justice was done. That is, that the people's rights were protected both from each other and from the king's government. The king's courts was expected to adjudicate the law common to those courts and to the realm, hence the development of common law. The king's highest court of all, Parliament, arose sometime in the 13th century, as we know from discussions today, after the drafting of Magna Carta in 1215, although many colonists continued to believe that Parliament preceded 1215. And of course, Parliament was composed both of the feudal nobles that eventually became the House of Lords and of representatives from the boroughs and counties of the realm that eventually became the House of Commons. Unlike the 18th century English Parliament, its medieval predecessor was convened by the king only sporadically and did not have as yet any direct responsibility for governing the country. That was the king's responsibility. Instead, the responsibility of Parliament was mainly limited to voting supplies to the king to enable him to govern, presenting petitions to the king for the redress of popular grievances, and as the highest court in the land, correcting and amending the common law so as to ensure that justice was done and that the people's rights were protected. This correcting and amending of the law was not regarded as legislation in any modern sense, for medieval Englishmen thought of law not as something invented, but as something discovered in the customs and precedents of the past. The modern idea, the positivist idea of law as the command of a legislative body, was as yet inconceivable. Indeed, law was equated with justice, and its purpose was to protect the rights of the people from each other and from the king. Thus, the king had his rights to govern, and the people had their equally ancient and equally legitimate rights to their liberties and their property. Indeed, in some important sense, I think, and certainly the colonists thought so, the whole of English constitutional history was seen as a struggle between these two competing sets of rights. Because the king, in trying to fulfill his responsibility for governing the realm, often infringed upon the customary rights of the people, Englishmen periodically felt it necessary for the king to recognize their rights and liberties in writing. These recognitions in the Middle Ages took the form of coronation oaths, assizes, and charters issued by the crown. Magna Carta was the greatest of these, and it was reissued, as we heard today, many times. Now, these struggles between the two sets of rights, those of the king and the people, came to a climax in the 17th century. Magna Carta was rediscovered, in a sense, and repeatedly invoked, especially by Sir Edward Coke, the English Chief Justice of Common Pleas. Only after a bloody civil war, and one king had been beheaded, and another driven from his throne, was the centuries-long struggle between the king and people finally settled in the glorious revolution of 1688-89. In 1689, Parliament enacted a Bill of Rights that became nearly as famous as Magna Carta as a documentary barrier to the encroaching power of the crown. Now, this was the understanding of English history that the colonists brought to the Imperial Debate in the 1760s and 70s. When the Stamp Act was passed by Parliament in 1765, which, by the way, is 250 years ago, so there's going to be a celebration of the Stamp Act this year, the colonists regarded this action as if parliamentary law were just another oppressive action by an encroaching crown. They initially drew no distinction between the king and the Parliament and contended that Magna Carta protected them from both king and Parliament. In its petition to the king, the Stamp Act Congress, which met in New York in 1765, claimed that the Stamp Act denied Americans the right of taxing ourselves and the right of trial by our peers, both rights, they said, confirmed by the Great Charter of English Liberty. For Englishmen in the mother country, this colonial contention made no sense at all. It was one thing to invoke Magna Carta against the power of the crown. That was what it originally had been designed to do. But it was illogical to invoke Magna Carta against the power of Parliament. Tyranny came from the monarch, not from Parliament. In fact, Parliament was the bulwark, the protector, the creator, if you will, of the rights of Englishmen against the crown's tyranny. By the middle of the 18th century, most Englishmen in the mother country no longer conceived of Parliament as a high court making judgments that could be declared null and void by other courts, as Coke had done in the 17th century. Dr. Bonham's case, for example, that was mentioned today. Parliament now, embodying the King, Lords, and Commons, had become a modern legislature whose enacted will was law. Although Coke had said that Magna Carta will have no sovereign, that was no longer true. The sovereignty of Parliament trumped all declarations of rights and liberties. In fact, Parliament was the body that issued those declarations of rights and liberties against the power of the king. The glorious revolution of 1688-89 had changed everything. Parliament had become the sole protector of the rights and liberties of Englishmen against the crown's encroachments. All the great affirmations of English liberties in the 17th century, the Petition of Right, the Act of Habeas Corpus, the Bill of Rights, they were acts of Parliament, statutes, not different in form from other statutes passed by Parliament. Englishmen now describe Magna Carta, even Magna Carta, as the creation of Parliament, and thus it was a document that could be changed by Parliament. Because Parliament was the guardian of the people's liberties against the power of the king, to oppose Parliament in the name of liberty, as the colonists were trying to do, was incomprehensible to most Englishmen in the 18th century. Magna Carta was thus no help whatsoever in dealing with the sovereignty of Parliament for the colonists. The Sugar Act, the Stamp Act, the Townshend Duties, the Coercive Acts, all these measures of the 1760s and 70s that the colonists so deeply resented and believed were in violation of the English Constitution were acts of Parliament, not acts of the king alone. How then could Magna Carta, which limited only the king, be used to limit the actions of Parliament? That's the problem the Americans faced. In these circumstances, Magna Carta had no applicability for the colonists whatsoever. It had traditionally been understood as a curb on the ability of the king to harm the people's rights. Did it make any sense any longer to invoke Magna Carta when the oppressive power being exercised belonged to Parliament instead of the crown? For Englishmen at home, Parliament had become the supreme sovereign lawmaking body of the nation. Parliament was sovereign because all the estates of the realm, king, lords, and people, were embodied in it, and thus everyone in the nation presumably assented to its actions, including, in most English minds, the colonists, who were thought to be virtually represented in the House of Commons. The sovereignty of Parliament, said the great English 18th century jurist William Blackstone in 1765, meant that it could do everything that is not naturally impossible to be done, interpreted in the 18th century to mean that it could do everything but make a man a woman. Nowadays, of course, it could do even that. And there was no institution, no constitution, no judge, no court, no Magna Carta to check it. If the Parliament will positively enact the thing to be done, which is unreasonable, wrote Blackstone, I know of no power that can control it. What Parliament does, he said, no authority upon earth can undo. Now, most Englishmen in the mother country could not imagine anyone defying Parliament in the name of liberty. That was a logical contradiction to them. Parliament was the protector, the guardian of English liberty. We today, I think, can scarcely imagine the kind of emotional commitment that 18th century English Whigs had for Parliament. Who could have liberty without Parliament? Certainly, Governor Thomas Hutchinson of Massachusetts, who became the arch-loyalist and most hated man in America, thought Parliament was crucial to English rights. Indeed, he could not imagine the colonists wanting to be outside the protection of Parliament. And in early 1773, he naively thought that he could show the people of Massachusetts the foolishness of their defying a sovereign parliament. In a speech to the Massachusetts General Court, which is the legislature of colonial Massachusetts, in January of 1773, Hutchinson declared that he knew of no line that can be drawn between the supreme authority of Parliament and the total independence of the colonies. It is impossible, he said, there should be two independent legislatures in one and the same state. For although there may be one head, the king, yet the two legislative bodies will make two governments as distinct as the Kingdom of England and Scotland were before the Union. Now, if the governor thought that his logic would intimidate the colonists into accepting Parliament's sovereignty, he was sadly mistaken. In response, the Massachusetts House of Representatives declared that if there be no such line between the supreme authority of Parliament and the total independence of the colonies, the consequence is either that the colonies are thus vassals of Parliament or that they are totally independent. As it cannot be supposed, the House went on, as it cannot be supposed to have been the intention of the parties to the compact, a very important phrase I'll come back to, the parties to the compact, that we should be reduced to a state of vassalage, the conclusion is that it was their sense that we were thus independent. The House then went on to accept Hutchinson's logic that since two independent legislatures in the same state were impossible, the colonies had to be distinct states from the mother country, united and connected only through the king. Now, soon other patriot leaders reached the same conclusion. By 1774, confronted with these repeated claims of the sovereignty of Parliament, that Parliament had the authority as stated by the Declaratory Act of 1766 to make laws binding the colonists in all cases whatsoever, confronted with that kind of logic, the colonists decided that they needed to break free of all connections to Parliament and tie themselves solely to the king. Now, historians have called this, and this every intellectual, American intellectual by 1774 reached this position. Now, historians have called this the Commonwealth theory of the empire that the American patriots anticipated, because it anticipated the imperial structure worked out by the Statute of Westminster in 1931 that created the modern British Commonwealth, by which all the separate states, Canada, Australia, New Zealand, have independent legislatures with a common head in the crown. And that's the existing situation today. They all are under Queen Elizabeth. Now, this Commonwealth theory of the empire revitalized Magna Carta for the colonists. If they couldn't use Magna Carta against Parliament, they now were tied to the crown. Well, now Magna Carta made sense, and it becomes instrumental again in their arguments. It became the symbol of the limits on the king's power and central to their cause. In response to Governor Hutchinson, the Massachusetts House had referred to the parties to the compact. And that image of a compact or contract between parties now became increasingly important to the colonial polemicists. They now began invoking Magna Carta as an example of such a compact or a contract, a document that was written down in which rights were made explicit. During their brief century and a half of history, the colonists had often had written documents in support of their liberties. They had especially invoked their colonial corporate charters that the Crown had issued in the 17th century to individuals like William Penn or to groups like the Puritans that went to Massachusetts Bay. Nearly all of these charters were littered with the language and content of Magna Carta, guaranteeing the people's rights. Penn was especially enamored of Magna Carta, and in 1687, he arranged for the printing of the New World's first edition of this famous document. Now, these charters issued by the Crown were originally empowering documents, creating corporations to do things that had not existed before. But they quickly developed into something very different. They became both frames of government for the colonies and defensive documents, sort of miniature Magna Cartas, that the colonists repeatedly invoked as barriers to limit the power of their royal governors. John Adams, for example, called the Massachusetts Charter of 1691 a kind of Magna Carta, protecting the rights and liberties of the people of Massachusetts. On the eve of the Revolution, declared one New Englander, these several charters, or where these were were lacking. Their commissions to their governors have ever been considered as equivalent securities. These charters had become transformed into what this writer said, from their subject matter and the reality of things, can only operate as the evidence of a compact between an English king and the American subjects. They were reciprocal agreements, wrote Joseph Hawley, who was a patriot from Western Massachusetts in 1775. Reciprocal agreements made and executed between the King of England and our predecessors. Magna Carta was now described in the same way, as a kind of contract or bargain negotiated with King John, and as such it took on a new relevance now for the colonists. This imagined contract between the king and the people was not the contract described by John Locke, which was a contract among the people themselves to form a society. Instead, this contract was the Whig contract that ran through much of 18th century English political culture. It was what justified the people's obeying the prerogative decrees and edicts of the king. This contract was an agreement between the king and people, legal or mercantile in character, in which protection and allegiance were the considerations. The people owed allegiance to the king in return for his protection. Now, crude as this contractual image may have been, it made comprehensible the always perplexing problem of why the people should obey the prerogative decrees of the king. Why should they? They're not consenting to them. The people had certainly not consented to these decrees or these edicts. Obedience to the king, wrote James Wilson in 1774, one of the leading intellectuals, a Scot in the colonies. Obedience to the king, he said, came from allegiance, which was not the same as consent. Allegiance to the king and obedience to the parliament, said Wilson, are founded on very different principles. The fact that he had to say this in a pamphlet suggests that there was a good deal of confusion among some of his colleagues. Allegiance is founded on protection, obedience to parliament on representation. And inattention to this difference, Wilson went on, has produced much uncertainty and confusion in our ideas concerning the connection, which ought to exist between Great Britain and its colonies. John Dickinson, famous Philadelphia lawyer, tried to explain the distinction. In his Letters from a Farmer in Pennsylvania of 1688, the most important pamphlet until Thomas Paine's Common Sense in the whole period, in his letters, he argued that Americans could constitutionally accept the royal governor's suspension of the New York Assembly as a legal act of prerogative, but they could never accept such a suspension by act of Parliament. For that, said Dickinson, gives the suspension a consequence vastly more affecting, involving a legislative action to which the New York colonists had not consented. You see that difference. You can accept the king doing it, but you can't accept the Parliament doing it. Once the colonists in 1774 had cut loose from all connections to Parliament and tied themselves exclusively to the Crown, with no need any longer for consent, they began to describe themselves, as one Massachusetts writer said in 1775, as a distinct people who had engaged in a private bargain with the Crown, one that resembled that of Magna Carta. It was a contract, said this writer, in which the British people and their Parliament were total strangers, even though they have in some instances strangely intermeddled. Now, when the king withdrew his protection in 1775 and 1776, in the colonists' eyes, the contract was broken, and they were free, legally now free, to withdraw their allegiance. To emphasize their exclusive connection to the Crown, however, Americans in the Declaration of Independence in 1776 scrupulously avoided any mention of Parliament. Now, if you go through that declaration, it says that you, George III, have done this, this, this. No mention, even though all of the acts of Parliament were the things they objected to. The Stamp Act, the Townshend Duties, the Coercive Acts. No mention of Parliament. The closest they come is say, you, George III, have conspired with others. That's it. That's the recognition of. They were lawyers and very scrupulously in trying to define their relationship at that point was only to the king, and therefore there was no need to mention Parliament whatsoever. That's how they saw the document, the Declaration of Independence. Now, when they came to draw up their new state constitutions in 1776, in some sense far more important than the federal constitution, which was derived from this initial state constitution-making experience, They sought to apply lessons that they had learned from the decade-long imperial debate. Now, one was to, of course, avoid the corruption that they thought pervaded the English Parliament. They believed that the king bought off members of Parliament by giving them crown offices. Hence, in their state constitutions, they forbade members of their state legislatures from simultaneously holding office in the executive branch. Now, this was repeated, of course, in Article 1, Section 6 of the later federal Constitution. What it meant was that it forever, presumably forever, prohibited us from ever developing a cabinet parliamentary system of government. When Senator Clinton became Secretary of State, she had to resign her Senate seat from the state of New York. If she were a member of the ministry in England, a cabinet minister, she would have to keep the seat in Parliament, and without that seat in Parliament, she couldn't serve in the ministry. If you can see that, you see the difference that our prohibition of dual office holding, if you will, the significance of it at the time of the Revolution. At the same time, we came to realize that from this imperial debate that the fundamental laws and liberties of a constitution were never really secure unless they were specifically defined and codified. They had to be brought down from some ethereal presence in the culture and, like Magna Carta, codified and made explicit in written documents. The fundamental law of the Constitution had to be somehow separated from all of the parts of government and set over the entire government, including the representative legislatures. Now, before the American Revolution, in the Anglo-American thinking, a constitution had rarely ever been distinguished from the government and its operations. Traditionally, in English culture, a constitution had referred both to the way the government was put together or constituted and to the fundamental rights the government was supposed to protect. The 18th century English Constitution was an unwritten mixture of laws, customs, principles, and institutions, and included all the parliamentary enactments. For Englishmen, therefore, as Blackstone pointed out, there could be no distinction between the constitution or frame of government and the system of laws. All were of a piece. Every act of Parliament was a part of the Constitution, and all law, both customary and statute, was thus constitutional. Therefore, concluded the 18th century English theorist William Paley, the terms constitutional and unconstitutional mean legal and illegal. This is still, of course, true in England today. Now, nothing could be more strikingly different from what we Americans came to believe. Indeed, it was precisely on this distinction between legal and constitutional that the Americans and English constitutional traditions diverged at the time of the Revolution. During the imperial crisis, the colonists had come to realize that although acts of Parliament like the Stamp Act of 1765 might be legal, that is, in accord with the acceptable way of making law, such acts could not thereby be automatically considered constitutional, that is, in accord with the basic principles of rights and justice that made the English Constitution what it was. It was true that the English Bill of Rights and the Act of Settlement of 1701 were only statutes of Parliament, but surely, the colonists insisted, they were of a nature more sacred than those which established a turnpike road. Now, under this kind of pressure, the Americans came to believe that the fundamental principles of the English Constitution had to be lifted out of lawmaking and the other institutions of government and codified and set above them. In all free states, said Samuel Adams, the Constitution is fixed, and as the supreme legislature derives its power and authority from the Constitution, it cannot overleap the bounds of it without destroying its own foundation. Besides, he added, Magna Carta had been very explicit. Thus, in 1776, when Americans came to make their own constitutions for their newly independent states, they inevitably sought to make them fundamental and write them out in documents, to make them very explicit, as Magna Carta was. These state constitutions of 1776, 1777 incorporated many provisions of Magna Carta. They were immediately translated into several European languages, and they captured the imaginations of enlightened people everywhere in Western Europe. By creating written constitutions that were distinct from government, we Americans went down a very different constitutional path from that of the English. These colonists, these American revolutionaries, permanently transformed the idea of a constitution to the point that today, when new states create a constitution, they inevitably write them down. Over the last 70 years, there have been dozens, maybe hundreds of constitutions created. And the only state I know of that has an unwritten constitution in that period of state-making is Israel. All the others wrote down their constitutions, including Afghanistan and Iraq and so on in recent years. By the end of the Revolutionary era, a constitution had become superior to all the operations of government. It was, as Thomas Paine said, a thing, antecedent to a government, and a government is only the creature of a constitution. And, said Paine, it was not a thing in name only, but in fact. As a written document, it could be possessed by every family, said Paine, and carried about like a Bible or like Magna Carta. It could be quoted and cited article by article. Such a constitution could never be an act of the legislature, not if it were to be a check on the legislature. Already Americans were coming to think that their constitutions checked even the representative legislatures. Now that's a major step, way beyond, of course, what Magna Carta originally meant. But it was one thing to define the Constitution as fundamental law, different from ordinary legislation and circumscribing the institutions of government. It was quite another to make such a distinction effective. Since the revolutionary state constitutions in 1776 were created by the legislatures, they presumably could also be changed or amended by the legislatures. Some of the constitution makers realized the problem and tried to deal with it. Delaware, for example, provided for a supermajority, 5/7 of the legislature, for changing its constitution. Maryland said that its constitution could be amended only by a 2/3 vote of 2 successive legislatures. Most states, however, simply enacted their constitutions as if they were regular statutes. Everyone believed that the constitutions were special kinds of law, but no one quite knew how to make them so. Now, in the years following the Declaration of Independence, Americans struggled with this problem of distinguishing fundamental law from statutory law, and none did this struggle more than Thomas Jefferson. In 1779, Jefferson knew from experience that no legislature elected by the people for the ordinary purposes of legislation only could restrain the acts of succeeding legislatures. Thus he realized that to declare his great act for establishing religious freedom in Virginia to be irrevocable would be of no effect in law. Yet we are free, he wrote into his 1779 bill in frustration. We are free to declare, and do declare, that if any act shall hereafter be passed to repeal the present act or to narrow its operation, such act will be an infringement of natural right. In effect, he was placing a curse on future legislators of Virginia. That's all he could do to warn them, don't do anything to hurt this act or you'll be violating natural right. But he realized that such a paper declaration was not enough and that something more was needed. By the 1780s, both he and his friend James Madison were eager, as they said, to form a real constitution for Virginia. The existing one, they said, was merely an ordinance with no higher authority than the other ordinances of the same session. They wanted a constitution that would be perpetual and unalterable by other legislatures. The only way that could be done was to have the Constitution created, as Jefferson put it, by a power superior to that of the legislatures. By the time Jefferson came to write his notes on the state of Virginia in the early 1780s, the answer to him had become clear. To render a form of government unalterable by ordinary acts of assembly, he said, the people must delegate persons with special powers. They have accordingly chosen special conventions to form and fix their governments. Massachusetts in 1780 had led the way. It had elected a convention specially designed to form a constitution and had then placed that constitution before the people for ratification. Now, we take these procedures for granted, but they stumbled and fumbled into them, and we have to appreciate how difficult it was to reach these conclusions. When the Philadelphia Convention drew up a new constitution for the nation in 1787, it knew what to do. It had this previous experience. It declared that the new Constitution had to be ratified by the people, meeting in state conventions called for that purpose only. Constitutional conventions and the process of ratification made the people themselves the actual constituent power. As enlightened Europeans realized, these devices were some of the most distinctive contributions the American Revolution made to world politics. But these were not the only contributions. With the conception of a constitution as fundamental law, immune from legislative encroachment, more firmly in hand, some state judges in the 1780s began cautiously, very cautiously, moving in isolated cases to impose restraints on what the assemblies were enacting as law, using the written constitutions as a kind of Magna Carta, as Coke had, to limit the legislatures. In effect, they said to the legislature, as George Wythe, who was judge of the Virginia Supreme Court, did in 1782, "Here is the limit of your authority, and hither shall you go, but no further." These were the hesitant beginnings of what would come to be called judicial review, that remarkable practice by which judges in the ordinary courts of law have the authority to determine the constitutionality of acts of the state and the federal legislatures. Now, the development of judicial review came slowly. It was not easy for people in the 18th century, even not easy for us today. Even those who were convinced that many of the acts of the state legislature in the 1780s were unjust and unconstitutional, it was not easy to believe that unelected judges could set aside acts of the popularly elected legislatures. This seemed to be an undemocratic usurpation of power. But as early as 1787, James Airedale of North Carolina, who was soon to be appointed an Associate Justice of the newly created Supreme Court, saw that the new meaning Americans had given to a constitution had clarified the responsibilities of judges to determine the law. A constitution in America, said Airedale, was not only a fundamental law, but also a popularly created law in writing, limiting the powers of the legislature, and with which every exercise of those powers must necessarily be compared. Judges, he said, were not arbiters of the Constitution or usurpers of legislative power. They were merely judicial officials fulfilling their duty of applying the proper law. When faced with a decision, he said, between the fundamental unrepealable law made specially by the people and an ordinary statute enacted by the legislature, which was not really the people, contrary to the Constitution, these judges must simply determine which law was superior. Judges could not avoid exercising this authority, he said, for in America a constitution was not a mere imaginary thing about which 10,000 different opinions may be formed, but a written document to which all may have recourse, and to which, therefore, the judges cannot witfully bind themselves. Although Airedale may have been wrong about the number of different opinions that could arise over a written constitution, as we know, he was certainly right about the direction judicial authority in America would take. The way was prepared for Supreme Court Justice John Marshall's decision in Marbury versus Madison in 1803, and the subsequent but bitterly contested development of the practice of judicial review, a practice that Europeans soon became aware of, and present-day Europeans have developed something very similar. In 1776, no one, of course, had foreseen the development of judicial review, but neither had anyone in 1776 even imagined the kind of strong national government that was created by the new federal Constitution in 1787. That Constitution immediately aroused powerful opposition. In the ratification debates, opponents of the Constitution raised all sorts of objections. The Anti-Federalists, they said the Constitution was aristocratic, that would lead to a consolidation of power, and most important, that it lacked a Bill of Rights. Where was the Magna Carta, opponents asked, that would limit the powers of this new, imposing national government? Now, in attempting, as you know, the final day or so, George Mason brought up the idea of the Bill of Rights. After 4 months, the rest of the delegates just rolled their eyes, and it was voted down unanimously, every state. But the Anti-Federalists picked it up, and it became the most potent argument they had. Now, in attempting to answer why the Constitution lacked a Bill of Rights, the Federalists, as the supporters of the Constitution called themselves, groped to explain the distinctiveness of this new system of government they had created. In doing so, in order to defend their lack of a Bill of Rights and the nature of the Constitution as they understood it, they had to play down the importance of Magna Carta as a model for the new national government. Magna Carta, or anything like it, made no sense in America anymore, said Noah Webster. A Bill of Rights against the encroachments of kings and barons, or against any power independent of the people, is perfectly intelligible, said Webster. But a Bill of Rights against the encroachments of an elected legislature, that is, against our own encroachments on ourselves, is a curiosity in government. How can the people tyrannize themselves? Since America had no prerogatives, no powers independent of the people, what was the point of a Magna Carta or a Bill of Rights? Now, this new national constitution, said the Federalists, may have been written, but it was not like Magna Carta at all, they said. It didn't even resemble their old colonial charters, which were grants from the crown. As James Madison pointed out, in Europe, constitutions were charters of liberty granted by power. That's what King John's issuing of Magna Carta had been. That's what the colonial charters had been. In America, said Madison, by contrast, constitutions had become charters of power granted by liberty, that is, by the people. The people created the power. They're not given the rights or acknowledge their rights in a Magna Carta-like way. So therefore, Magna Carta, said the Federalists, no longer had any relevance in these new circumstances. Now, the federal constitution, said the Federalists, was not at all a contract between rulers and people. Those existed in the old world. That's what Magna Carta had been. America was now different. Governmental power was not pre-existing. The people didn't have to bargain and contract with it in order to gain recognition for the rights in the way the barons had to bargain with King John. In America, sovereignty remained with the people, and they parceled out pieces of their power to various officials and various institutions of government. A traditional Bill of Rights or a Magna Carta under these conditions were unnecessary. The people only gave the government a few limited powers and retained for themselves all the rest, all their rights and liberties. Now, as ingenious as these arguments were, the American experience with written limitations on governmental power and their devotion to the symbolic importance of Magna Carta were too strong, and the Federalists eventually had to give way to the pressure for a Bill of Rights. And as Thomas Jefferson pointed out, and as Madison later echoed in 1790, to emphasize and press in order to justify a congressional adoption of the first 10 amendments, which he finally came around to accepting, he argued that a Bill of Rights would put a legal check into the hands of the judiciary, which could then take hold of in protecting the people's rights and liberties, even against their own representatives. So he came around to anticipate exactly what, of course, has happened. Now, with the adoption of the Bill of Rights in 1791, Magna Carta was once again brought front and center in the Americans' constitutional thinking. The national government was not as weak and not simply a bundle of parceled powers as the Federalists had claimed. By the 20th century, its powers had become far more formidable and far more pre-existing than King John's powers had been in 1215. The opponents of the Constitution in 1787, 88 had taken the long view and had been right in urging the addition of a Bill of Rights, a Magna Carta limiting the national government, the whole national government. Indeed, today, all our governments, both state and federal, have acquired far more power than the founders ever anticipated, and far more than King John could ever have imagined possessing himself. Consequently, we are in need of as many Magna Cartas as we can muster. Fortunately, not only were clauses from Magna Carta incorporated into the 5th, 6th, and 8th Amendments to the Constitution, but the language and ideas of this great document have become an integral and natural part of our jurisprudence. Over the last century, the Supreme Court has so often resorted to the provisions of Magna Carta that perhaps we have tended to take the document for granted. In a world in which tyranny still flourishes and the rights and liberties of people are constantly violated, it is important that we keep the central idea of Magna Carta alive, the importance of due process of law and the rights and liberties of the people against all governmental power. Maybe this 800th birthday celebration will remind us of how indebted we are to those barons at Runnymede in 1215. Thank you. Thank you very much.